The sheriff's deputy who shot and killed Sonya Massey could soon be released with conditions. All of this as he awaits trial. The Illinois State Attorney of Sangamon County reacting in a statement earlier today saying Sean Grayson has been granted pretrial release by an appellate court panel, but plans to file a request to the Supreme Court and ask that Grayson remain detained. This comes ahead of the former deputy's court appearance tomorrow. He faces first-degree murder for shooting Massey in her kitchen after she called 911 about a possible intruder. Joining me now is criminal defense attorney and former prosecutor Bernarda Villalona. I apologize, Bernarda. Let's get started here. There was a unanimous decision found by the District Appellate Court that previous ruling in July to detain Sean Grayson be detained was improper. What did the prosecution fail to do or fail to prove in order for the District Appellate Court to decide this?
So the District Appellate Court is saying that the prosecution failed to provide sufficient evidence to show that there exists no other terms in order to prevent the dangerousness to the community, because the purpose of having him pretrial detained is if there's a danger to the community where nothing that's put in place of having Grayson free to the community will prevent that type of danger from happening.
Well, Bernarda, the opinion also ordered a hearing for his release upon suitable conditions. What could these conditions include?
So these conditions can consist of having electronic monitoring placed on him, having to be in the home for a certain amount of time, preventing him from actually being outside of his home except for probably medical treatment or to appear in court or to meet with his attorneys. And also, if there's any need for him to be outside, he'll have to get pre-approval. But of course, the electronic monitoring is one of those main conditions that are usually set. I'm surprised here because I would have thought because of the charge itself, first degree and murder in the first degree, that he would be detained just simply on the charge itself because of the egregiousness of that charge and the allegations where he actually shot Sonya Massey in the face in her own home.
Yeah, I was going to ask you what your take was on this. What is the prosecution saying about all of this, and does this pose a potential setback in their case against Grayson?
Well, the prosecution has vowed to appeal this to the Illinois Supreme Court. The question would be is whether the district court will grant the defendant to be released in the meantime while it's being appealed to the Supreme Court of Illinois. It doesn't actually set back the prosecution in terms of whether he's out in the street or whether he's in custody, because the prosecution is going to continue. They'll continue to be preparing their case, preparing their witnesses, so when the trial actually takes place. So it's not a major setback for the prosecution. But of course, as a prosecutor, it's always easier and better when the defendant is in custody.
All right, Bernarda, before I let you go, I want to ask you about the subway chokehold case. We know jurors are expected to hear closing arguments on Monday in the homicide trial of Daniel Penny. Of course, he's the veteran who put Jordan Neely allegedly in that fatal chokehold on a New York City subway car last May. What do you think prosecutors and the defense are going to say to jurors?
Well, the defense is going to argue to the jury that the cause of death was not due to the chokehold, but rather a combination of actually him having drugs in his system, of him being a schizophrenic, and from him also suffering from sickle cell anemia. Now, in terms of the prosecution is going to argue that he wasn't justified. He wasn't justified in the sense of holding Mr. Neely with a chokehold for over 5 minutes, that it was excessive. While he may have been justified initially, he wasn't justified for that extent of time, especially given that there was no one else left on that train and that the only people that were on the train is the defendant plus 2 other people. So there was no longer a threat and no longer a need to use deadly physical force on Mr. Neely.
And we'll certainly see how those closing arguments play out. Bernarda, thank you so much for weighing in on this.